All right, we'll get going in just a second here. That's my cue to Deb in the booth to start the webcast for those who are watching but are not able to eat, as all of you are. Our speaker today is Lou Michels. He's a litigation attorney with McGuireWoods operating out of its Chicago office. He's a 1977 graduate of the United States Air Force Academy out at Colorado Springs, being commissioned as a second lieutenant in that year and then going on active duty with the United States Air Force. Some 5 years later, Lou was selected for a very prestigious program called the Funded Legal Education Program, whereby the services take an active duty officer and send him to law school and pay all his bills. It's a very select program, obviously, because the federal government's paying for it, and Duke was the recipient of having Lou here with us. He graduated cum laude in 1985. He then went back on active duty with the Air Force, this time as a judge advocate, and served until 1991 when he left the service to join McGuireWoods in private practice, and he's been with that firm ever since, first in its Richmond office, then in Northern Virginia, and now, as I said earlier, out in Chicago. He did stay in the Air Force Reserves, however, and about 3 years ago, he retired from the Air Force in the grade of lieutenant colonel. He'll be speaking with us primarily about the unique legal issue that probably could never have arisen outside the context of the armed forces of the United States, particularly during a time of heightened tension and even before the war on terrorism. The Anthrax Vaccination program goes back almost 10 years, and I will tell you that Lou Michels has been at the center of the litigation effort challenging that program for a number of years. On a more personal note, I had the pleasure of knowing Lou when he was wearing the Air Force uniform, and I'm serving with him in Tactical Air Command and Air Combat Command at Langley Air Force Base. I've got the highest respect for him as an Air Force officer, as an attorney, and therefore on behalf of both the Program on Public Law and the Center on Law Ethics and National Security, it's a distinct personal pleasure to welcome back to Duke Law School one of our more distinguished graduates of the class of 1985. Lou?
Thank you. Well, let me just say what a different perspective it is speaking from this end of it versus sitting up where you are. And I will try not to avoid back when I was here stories. I must confess a certain turmoil right now because my alma mater is playing Duke tonight in basketball in Kansas City. And, you know, they're actually, the Air Force, which has a height restriction for admission, and I don't think as a player taller than 6'8", is going to be in for an interesting little run when they see how things go. But they tend to play a perimeter passing game anyway, so I'll keep my fingers crossed that they can keep it competitive for at least the first half. Let me, and I'm sorry, I'm going to pace. So I do trial work, and it's very hard for me to stay behind a podium anyway. So I'm going to pace, but I do want to talk to you a little bit about this the Anthrax Vaccination Program and sort of give you a perspective on it, and really why this is an issue for most of us, and it's an issue that you ought to think about. When DOD decided in 1997 that it was going to start an inoculation of about 2.1 million people, a mandatory inoculation of about 2.1 million people with the anthrax vaccine, it really represents what I consider to be the first public health response to a bioweapon issue. We're going to give you a quick overview of the program, and you've got the handout, I think, that has my slides on it. But the point that I want to make is that this program and the way it's been handled and the way it's been monitored and the way that FDA and DOD have interacted kind of provides a model, if you will, and a rather, from my perspective, a rather frightening model of how federal agencies are going to react in a situation where we have a potential bioweapon situation arise and we don't have a licensed vaccine in place that we can use to respond to it. Many of you may not be aware of the fact that when you join the military, you are subjected to a number of mandatory or forced inoculations. You're basically ordered to take the shots, and you don't really have a say in it. This kind of an approach leads to some interesting results, and both Scott and I were on active duty in 1976 when the 1970s version of avian flu, something called swine flu, was predicted to sweep through the United States and make everybody sick and cause people to get really ill and run high fevers and throw up and do all kinds of unpleasant stuff. As a result, Scott and I were inoculated, ordered to take the shots with an experimental swine flu vaccine, which had just been rolled out. Now, the problem with that vaccine, as I recall, because I was at the Air Force Academy then, and there were about 4,000 cadets there, and they inoculated 1,000 cadets a day. And after the first day, 250 people showed up or reported in ill at sick call. 30 were hospitalized. The next day, that number went to 500 out sick, with an equal number, we doubled the number going to the hospital, and it proceeded from there. So at the end of the 4-day inoculation run, you had about 1,000 people who were unable to show up for classes and about 100 hospitalizations as a result of the vaccine. That's a pretty high adverse reaction rate. The Air Force just basically said, look, in case we get swine flu outbreak, this will be an acceptable an acceptable side effect. These are acceptable rates. Nobody died. What are you complaining about? Shut up and go back to class. To a certain extent, that attitude kind of runs through this anthrax program, except that the side effects from this vaccine are substantially worse. And I'll talk a little bit about that. But just to give you an idea of them, they range from the minor, what I consider to be minor reactions, the redness, swelling, and stuff like that, to 6 deaths that have been linked to the vaccine, to what I consider to be something almost worse than that. I've got at least one acquaintance, a female JAG, who suffered some kind of, and I cannot remember, I won't give you the exact name of the disease, you won't remember it anyway, but the frontal lobes of her cerebellum began to deteriorate. This is a direct result of the shot. She went from being an on-duty or active-duty Air Force JAG to a medically discharged, basically unemployable attorney with full cognitive capacity, but when she talks, it sounds like she's been anesthetized, and she walks with a stagger, and in fact, when she's driving, she has to carry a special card with her that tells the police officer, look, I'm not under the influence of drugs or alcohol. This is a medical condition. There are a whole variety of side effects that this stuff is kicking out, and part of the reason is because it really wasn't adequately tested, and we're going to go through that here. The other thing I want you to keep in mind is that the service members that I represent, and I represented 6 service members who successfully sued to shut the program down 2 years ago, they have no other recourse. This is it for them. They cannot sue the vaccine manufacturer for negligence. They cannot sue the government for negligence in forcing them to get the shots. They cannot sue to get medical treatment or lost earnings capacity. This is all handled through the VA. So these folks have literally no other recourse other than to try to get the program stopped. So let's talk a little bit about the vaccine inoculation program. Began in 1997. It was the brainchild of then Secretary of Defense William Cohen. This is in the Clinton administration. Secretary Cohen is a bioweapons guy. I mean, this was his legacy program. I'm going to put the first run of preparing people for bio warfare in a situation where we don't have a clear threat sitting in front of us. We're going to use anthrax as our model, because the military had a vaccine at that time that, at least to the leadership of DOD, was represented as being licensed and ready to go. Mandatory shots began in 1998. Almost immediately there were problems with the program. It turns out that the people manufacturing the vaccine, an outfit called Bioport up in Michigan, had not been able to pass an FDA inspection of their facilities for manufacturing the vaccine for several years. Ultimately, FDA shut down the facility shortly after the program began. This is a bad thing. Shut the facility down, and the DOD had to resort to using backdated, expired stocks of the vaccine to inoculated service members. One of the things that you find in these kinds of programs is that they develop what I refer to as an institutional momentum. And by 1998, with the Secretary of Defense, the Chairman of the Joint Chiefs of Staff, and the senior leadership of the Department of Defense, both military and civilian, on board with this program, it had lots of momentum. So the fact that the manufacturer had been shut down by FDA and was really not an issue. This was something, just a small bump in the road, and the push was to say, look, have we got other stocks of the vaccine we can use? Yes. Are they outdated? They might be, but we think we can get a mechanism in place to redate them. So we literally had people clearing and wiping the expired dates off bottles of vaccine and relabeling them to give to service members. Now that stock of vaccine would later be declared by FDA to be absolutely void and unusable. Nevertheless, that's what we started putting into people in 1998. The program was scaled back in 2000 after we ran through the initial expired stocks and FDA figured out what was going on. The DOD said, okay, we're going to run out. We can't inoculate 2.1 million people, so we're going to shut down here for a while. And they scaled the program back in 2000. In 2003, I filed suit representing 6 DOD service members and DOD civilians and got a preliminary injunction in December of 2003. That shut the program down for 2 weeks. FDA then, in response to a request from the Department of Defense, rushed out a final rule and order to try to correct the problems, the deficiencies that we had identified in 2003. The program restarted, except for the 6 people that we represented. The injunction was effective as to them. The program restarted and then was permanently shut down in October of 2004. That's when we won summary judgment on the issue of whether the vaccine was properly licensed. The court found that it was not on summary judgment, shut the program down in 2004. The government then responded not by fixing the vaccine itself, but by moving under something called the Project BioShield Act, and there's a citation to that in your materials. This is a very interesting statute. Actually, it's kind of scary because the Project BioShield Act is designed to deal with a situation where we have some kind of biological event in the United States that causes the president and the executive branch to say, we don't have an adequate remedy here. The best we can do right now is experimental medication, and we're going to have to authorize that without testing. And under those circumstances, we will force inoculation of whoever. That's BioShield. The government started a voluntary inoculation in June 2005 under Project BioShield, using the same vaccine. In February of this year, Court of Appeals dissolved the injunction because FDA updated its paperwork on the vaccine. The program is restarting now on a mandatory basis. My next lawsuit is scheduled to kick off in probably about 10 days after Thanksgiving. I have the complaint already drafted. Temporary restraining order paperwork is already put together. We will proceed to sue again to shut it down on somewhat different bases. The key to the litigation in trying to stop this mandatory inoculation program was a statute that had been put into effect after Gulf War I. Many of you probably have heard of something called Gulf War syndrome, an autoimmune disorder, for lack of a better term. Actually, it's a series of symptoms that affected troops coming back from the Gulf War back in 1991. That situation, which has been linked to all kinds of things, chemical and biological weapons exposure, chemical and biological weapons vaccines. The vaccines at that point, by the way, were experimental. Exposure to oil well fires, exposure to depleted uranium, exposure to a variety of other toxics that are present on any modern battlefield, at least a modern battlefield that the U.S. fights on. In any event, that condition and those circumstances, those medical problems, caused Congress to pass 10 U.S.C. 1107. And 1107 basically says you can't use experimental medications on troops without informed consent or without a presidential waiver. Okay? So, if the government wants to use an experimental medication on somebody, they've got to go higher up than just the FDA. The vaccines that were used in Gulf War I were in many ways experimental. We used an anti-nerve gas agent that was experimental. We used a rabbit fever vaccine, tularemia, that was experimental, and the anthrax vaccine, which at the time was not necessarily considered experimental, but not licensed for the use for which we were going to use it. That was all done under a memorandum of understanding between FDA and DOD. No informed consent, and in fact, to give you an indication of how many of the kind of problems that these soldiers faced in trying to get their health conditions rectified after Gulf War I, there was not even an annotation on the shot records of these soldiers that they had taken any of these vaccines. So they were basically being given stuff that A, they didn't know what it was, B, the people giving it to them weren't making a record of it, and C, it had been agreed to by a formal arrangement between DOD and FDA, but with no real medical approval. The military looks at vaccines not so much from a medical perspective as they do from a force readiness perspective. It's like a helmet, it's like body armor, it's like a weapon. You get this stuff to protect you, to keep you combat ready, to keep you combat capable. And so these discussions went on without a lot of involvement by people like the Surgeon General or anybody like this about, hey, what are we putting in people? And what are the long-term effects of it? All right, so 10 U.S.C. 1107, it precludes the use of something called investigational new drugs. That's an FDA term of art. An investigational drug is a drug for which an investigational drug application has been filed. You file an investigational drug application when you want to experiment. All right? So that's one status, or a drug unapproved for its applied use. That's an undefined term in the statute and under FDA. However, a drug unapproved for its applied use simply means a drug that the FDA hasn't licensed for the use you're going to be putting it to. And the President, of course, can waive informed consent if necessary. This statute was passed in '98, right around the time this program's kicking off. Now, the vaccine. The anthrax vaccine has a long and storied history. If you look at storied history as kind of a negative event. It was originally developed by the U.S. Army at a place called Fort Detrick up in Maryland, which is the epicenter of our biological and chemical weapons research capability. That's where it all comes together, and they were doing the research. And that's where they have a variety of labs that can be sealed hermetically, that they can keep people from getting exposed to stuff. And they were doing, at the time this thing was developed, they were doing human tests there. So they develop anthrax vaccine at Fort Detrick, and then somebody says, we got to test it. And the way they elected to test it was in a goat hair mill processing operation in New Hampshire. Why goat hair mills? Because the way anthrax is typically contracted by people in the field, if it's not a biological weapons attack, is through the handling of animal carcasses and hides. Animals pick up the spores are naturally occurring. Animals pick up the spores, they get into the fur, they get into their hides. People who are handling these things would come in contact with the spores. There are three types of anthrax. There's cutaneous, through the skin, in which spores come in, get in through a cut or an open sore, and the bacteria spread. There's gastrointestinal anthrax. That is, if you eat the flesh of an animal that's been infected with anthrax, you will develop anthrax in your GI tract. And then there's inhalation anthrax. That's the biological weapons version. That's when you inhale enough of these spores that are in the soil. You inhale enough of them to create an anthrax infection in your lungs. Cutaneous anthrax is almost never fatal. It's a localized disease. It doesn't take a lot to get the disease initially. It creates a black sore on your hand. It's readily treatable with antibiotics. Gastroanthrax is almost always fatal because when you take the stuff in, if you eat the flesh of an infected animal, you are getting enough of the bacteria in your system that it'll kill you fairly quickly, and by the time you start manifesting symptoms, it's too late. Inhalation anthrax, which is the bioweapons version, is also usually fatal. It has a mortality rate of somewhere between 80 and 90%, mainly because once you inhale the stuff, it takes about 7 days for it to manifest symptoms, but the symptoms that develop prior to that are things like coughing, sneezing, it looks like you got the flu. And so as a result, people ignore it until they get really sick, and by that time they get to the hospital, they're going to die. About a 90% mortality rate. So the vaccine was tested in these goat hair mills in New Hampshire because that's where they expected to see the spore exposure. The test results were such, they had a number of cases of cutaneous anthrax, they had a couple of cases of inhalation anthrax there, no cases of gastroanthrax because people weren't eating goat hair. But at the end of the day, which I probably shouldn't talk to you about that while you're having that lunch, although I don't know what's in there. If it resembles goat hair, you might want to spit it out. The test results were such that they could only get a prediction for cutaneous anthrax. And the researchers noted, we had some cases of inhalation anthrax here, but we didn't have enough cases to get a statistically valid result for inhalation anthrax. So instead, we know or we believe that it works against cutaneous anthrax. All right, that was the first version. The vaccine was later manufactured by Merck, and then the license passed to the Michigan Department of Public Health, which was manufacturing it for two audiences, or two groups of people that were going to use it. The first and main use was for the bioweapons research people at Fort Detrick. That's where most of the shots went, about 1,000 doses a year. Occasionally, there would be a call by somebody who was a veterinarian who might want to get inoculated if they were handling animals in areas where anthrax had been detected. But that was it. Very limited use vaccine, very limited distribution. Okay, in the process of licensing this drug, or this biologic, the FDA undertook a panel review. This becomes important later on because this is an Administrative Procedures Act issue. They undertook a panel review that published its results in 1979 and said, we find this stuff to be effective against cutaneous anthrax only. There's not enough information about inhalation anthrax. So we get a panel review in 79. In 85, 6 years later, the FDA finally gets around to soliciting comments on this recommendation, which they had to do under the statute that authorizes this license review. They solicit comments in 85. They get comments in 1985. And then it stops. The vaccine sits in this licensing limbo from 1985 forward. As I said, it was used under a Memo of Understanding in Gulf War I. Now, the Michigan Department of Public Health in 1996 files an investigational new drug application for inhalation anthrax for the vaccine. What does that mean? It means they want to conduct experiments to find out if the stuff works against inhalation anthrax. Why? Because the Department of the Army had come to the manufacturer and said, hey, we're going to start inoculating. We know the Iraqis, for example, have thousands of gallons of anthrax slurry that the UN weapons inspectors discovered in the post-Gulf War searches. They have thousands of gallons of anthrax slurry that we can't account for. Weaponized spores that can be developed into weaponized spores. We can't account for it. We want to begin inoculation. If we have to inoculate, we want to use a licensed product. This product is not licensed for inhalation anthrax. So we're going to file we want you to file an investigational new drug application and start the experimental process. 6 months later, DOD comes forward to FDA. Remember, FDA knows there's an IND pending. Comes forward to FDA and says, hey, we're going to start this inoculation program now. Is it okay? Do you believe the vaccine to be licensed for inhalation anthrax? What FDA says is, well, the license agreement doesn't say what it's licensed for. So basically, we think your interpretation is not inconsistent with the license. See the double negative? Not inconsistent with the license, which is a bureaucratic way of saying, you're on your own, guys. We're not going to make a call. That, by the way, that opinion was not issued as a formal FDA opinion, but was simply sent out as a letter, going back to DOD officials. Okay, after I shut the program down in 2003, guess what? That pending decision by FDA that's been pending since 1985 gets issued 8 days after we get the preliminary injunction. It had been sitting there for 16 years, I'm sorry, for almost 18 years, but suddenly magically turns around and they get the opinion out in 8 days. The injunction was granted on December 22nd. The FDA final rule and order issued on New Year's Eve. For those of you that are unfamiliar with Washington, D.C., I can't really characterize the period between Christmas and New Year's as really a hotbed of regulatory activity in the nation's capital, okay? And so, amazingly enough, this thing comes out. When it comes out, you know, I immediately argued to the court, to the judge, Your Honor, this is a ham-handed attempt. They rushed this thing out, and he stopped me and he says, how do you know it's been rushed out? And I said, well, because the version that I have has got handwritten comments on it where they were changing the language and then filing it in an effort to get it out in a hurry. The court ultimately invalidates the FDA approval here, shuts the program down in 2004. FDA issues a final approval of the vaccine in December of 2005. All right? So they took another year. They went back, got comments, and then promptly, just so you know, they collected comments on the vaccine. I put 17 boxes of papers in for review, and then promptly ignored the comments. Okay, problems with the vaccine. Why were we able to shut the program down, and what problems does the vaccine have? Well, the first one and the most obvious one, remember the definition. You can't use investigational new drugs on service members without their consent. The vaccine was in investigational new drug status when this program started. How do I know? Is it, you know, as one of my judges said to me, do you have something more convincing than Lou Michels on civil procedure? Yeah. I have the IND application. The government, the manufacturer, files an IND application. Under FDA regulations, that puts the drug in investigational new drug status. That was filed in 1996. It was not withdrawn until 2004. The vaccine was in that special status, that experimental status during that entire period. That enough, under the statute, is enough to shut it down. So that was the first problem. The vaccine was not licensed for this. The second problem was the improper validation in 2003, and the first two elements here are what the court used to shut the program down. Improper validation. In 2003, what FDA did was they whipped out this final rule and order with their penciled-in comments, handwritten comments on it, saying, look, we've approved the vaccine, it's fine, everybody go home. It's over. Nothing to look at here. The judge said, well, wait a minute, the statute says you got to have comments. And FDA said, well, we had comments. We had comments in 1985. And then we pointed out to the court that between 1985 and 2003, the FDA had actually added, they had about 2,000 pages in their administrative record up to 1995 on this vaccine. After 1985, they added another 4,000 pages of material after they shut the comment period down. Under the Administrative Procedures Act, you can't do that. That's illegal. It's improper. The court goes, I agree. If you want to issue a final rule and order based on all this new stuff that you're putting in here, then you're going to have to reopen the comment period and get additional comments and see what's there. So that was the basis for shutting down the program, finding the vaccine to be improperly licensed, finding it to be a drug unapproved for its applied use, finding it to be an investigational new drug. That shuts the program down in October 2004. Now, other problems with the vaccine. Remember I told you it had been manufactured by 3 different entities? Under FDA regulations, every time you have a new entity manufacturing it, you've got to go back and retest the thing to make sure they're doing it right. There's never been any test of the vaccine. None. Other than that original goat hair mill test, which was done on the Fort Detrick vaccine. All right? So, we have the FDA violating its own procedures with regard to testing. The second problem is the off-label use. It will probably not surprise you to learn that a vaccine, and the shot sequence for the vaccine goes like this. You get the initial stick, then you get another shot 2 weeks later, then you get another shot 4 weeks after that. Then 6 months after that, you get another shot. 12 months, you get another shot. 18 months, you get another shot. And then you get annual shots thereafter to maintain your immunity. Scott and I are intimately familiar with the movement of troops and people through the military. You move every 3 years, and if you're on deployment, you're moving every 6 months. It is very hard to track people in that kind of a situation. It's almost impossible to get them on any kind of regular shot schedule because people are flying, they're deployed, they're rolling around in the dirt, they're doing all the stuff that people in the military do on a day-to-day basis that makes it almost impossible to set up a schedule like this unless you make this a priority. The military did not make it a priority. As a result, we have consistent off-label use of the vaccine because nobody is following those shot sequences. and that shot schedule. In fact, as a matter of policy, DOD has said, look, if we can get 2 shots into you, that's enough. If I get 2 shots into you, you're okay. And if you have to restart the program after X number of years off of the program, we'll just pick up where we left off. The head of the program is a pharmacist for the Army who has reported that, you know, really this whole shot sequence and makeup of the vaccine, it's a lot like mixing a cake. You can leave out some ingredients, you can get the ingredients wrong, and it really doesn't make any difference in the ultimate taste of the cake. And this vaccine program is kind of like that. Now, if that doesn't scare the living daylights out of you, I don't know what will, because you can think about how much variation is going on with the vaccine and the dosages that people are receiving under something like that. The testing procedures used that FDA has used to certify the vaccine, again, the goat hair mill testing outcomes, are statistically invalid, and we've demonstrated that with a modern statistical analysis. Specifically, modern statistical analysis shows that the numbers that were used by the scientists when they did the original tests on this thing are invalid for inhalation anthrax in any level and only minimally valid for cutaneous anthrax. In other words, the vaccine is probably just a little bit better than nothing for skin anthrax, cutaneous anthrax. And the only way that we worry about cutaneous anthrax, ladies and gentlemen, is if the Iraqis or the Afghanis or the North Koreans are going to bombard us with the carcasses of dead animals. Now, here's where it gets a little disturbing. The health issues. Autoimmune disorders. The vaccine has a higher level of autoimmune disorders associated with it. What am I talking about? I'm talking about 23, 24, 25-year-olds developing rheumatoid arthritis that is so severe that they can't walk. I'm talking about people developing MS at 20, 21, 22. I'm talking about people developing this brain shrinkage condition that I talked about earlier, or other cardiovascular problems where your immune system literally begins to attack the body. And the vaccine, in a large percentage of people, triggers that kind of response. In addition, birth defects. The vaccine was never tested on women. The people working in those goat hair mills that received the initial shots were all men. There was never any test about things like fertility, birth defect issues, and in fact, the vaccine has been positively linked to an increase in birth defects among young women taking the shot who then have kids. As I said earlier, 6 deaths have been linked to the vaccine. Short answer on this, when you see this list of health effects, what I can tell you safely is this. This vaccine, and these again, this is something, are not my words. If you look at one of the handouts, I believe it's from Dr. McGuire, his report there gives a fairly detailed analysis of some of the problems that they're seeing. McGuire recently testified at a claims tribunal that this vaccine is significantly worse in terms of health effects than any other vaccine that he can think of for any other condition, including smallpox, DPT, all the other shots that we get, polio, what have you. Anthrax vaccine has more side effects and more diverse side effects than any of those. The vaccine's never been tested regarding inhalation anthrax, ever. They can't test it on animals because they don't have something called a correlative immunity to test it. Moreover, it's never been tested regarding different types of anthrax. You might remember that the anthrax attacks that occurred in this country in 2001 involved something called the Ames strand of anthrax, because it came out of Iowa State, Ames, Iowa. That's where they identified that strain of anthrax as coming from. Well, the Ames strain of anthrax is a different version of anthrax than the anthrax that's used to develop the vaccine. And the manufacturer has absolutely no idea whether the strain that he's got in his vaccine will work against other strains of anthrax. No data, no test data. Moreover, we have a huge morale issue. And again, Scott remembers this because I sure do. When this program started in '98, we started seeing refusals right away. Now, the active duty folks, it was hard for them to refuse without consequences. They were going to be court-martialed, put in jail, thrown out of the service. There were about 500 of them. But the real effect from the Air Force's perspective, from my service's perspective, was what was happening in our Reserve and National Guard units, because those folks have a choice. They can leave. And what we saw was a large number of National Guard pilots, KC-135s, aerial tankers, fighter pilots, fighter bomber pilots, people who flew part-time, the weekend warriors, most of whom who had airline jobs during the day, during the week. They said, we're not taking this thing. We're not taking this shot. If we get sick from this shot and we're grounded from our airline job, we're out of luck. Because it was quite clear at that point that VA was not covering those losses. And if they got sick, they were done. So we saw a huge outflow of people out of the units. Okay. So this wonderful vaccine that the government puts into effect, as I said, creates all these problems. It's been stopped with a preliminary injunction, and for those of you that look at litigation, you know how difficult it is to get a preliminary injunction in federal court. It is extremely difficult. The standard of proof is extremely high. But the federal judge in Washington said, this is a no-brainer. You've got the investigational new drug application. You've got the fact that the vaccine is being used for a use for which it hasn't been approved. You're done. The government's done. We get a preliminary injunction on this. We get a permanent injunction on this. Does the government move to get a reformulation of the vaccine? No. Instead, we have the program restarting without correcting the problems that we've identified. The only problem they corrected was they put a comment period in, took comments, and then promptly ignored them. We have untested variations of the vaccine. The vaccine is now on its fourth permutation. The only variation of the vaccine that has been actually tested is the first one. It's gone through 3 other major manufacturing changes without being tested. We have the statistical problems in the original evaluation. In other words, the 1950s numerical evaluation that was done, and again, so you understand what was going on in the 1950s, people were using things called slide rules, all right, to get their numbers. And I'm just going to ask, I might as well date myself, who in here has seen a slide rule up close? Okay, well, that's better than I thought. Most of it, my experience with my associates has been, they start looking at you when you pull one of those things out and look at it, and they go, what in the heck is that? And you try to explain to them that you're basically guessing on what the numbers are between the little marks. There were statistical problems in the original evaluation. Those have never been corrected. That was done without benefit of computers or calculators or anything else. It was people writing numbers down and adding them up. We have the off-label use due to scheduling. As I said, DOD has formally adopted a policy saying, look, we don't really care what the scheduling says in the license. If you get 2 shots, you can take a break for as long as 5 years, and we'll just restart the sequence. If you're going into the theater, you come under the shots and we start sticking this stuff in you. When you go out of the theater, we stop. So, and these are the issues that have not been corrected. Litigation is again imminent. What do I mean by that? I mean that I've got a lawsuit ready to file. It's sitting in one version of it's sitting on my desk right now back in Chicago. The other version is on my co-counsel's desk in Washington, D.C. I expect it'll be filed either in the week or 2 weeks after Thanksgiving. And we will sue to try to enjoin the program again on these bases here. So this is sort of a preview of coming attractions. Any of you who've got contacts up in the FDA, call them and say, here it comes. Now, I don't think they really understand this stuff, but they'll figure it out once they see the complaint. The last part is interesting, an interesting side note to this. Many of you probably know that the military has a court system that runs in parallel to the civilian court system. It's called courts martial, military judges, fully litigated criminal trials, jury trials. The sort of capstone of that process is something called the Court of Appeals for the Armed Forces, or the CAF. And the CAF oversees the military justice system and makes decisions involving the military justice system for all branches of the service. In fact, Professor Everett was a professor on the precursor to CAF back when I was here. Those programs, that court is responsible for evaluating this. There were a number of cases out of the CAF or a number of cases that came up to CAF for review for people refusing orders to take the shot. They were court-martialed, thrown in jail, kicked out of the service, fined. That decision got to the CAF, and the CAF looked around and said, you know what? The military service chiefs have said this is a valid order and that the vaccine was properly licensed. And FDA says it was properly licensed, notwithstanding the fact that FDA has already been reversed twice on their licensing decision. The CAF ignores the federal district court's decision and says these orders were valid. Even though the vaccine was in illegal status at the time, the CAF has said these orders were valid. The only way you get a CAF decision reviewed by a civilian court is to go up to the Supreme Court. And I'm involved in filing the writ of certiorari to go for Supreme Court review on the CAF's decision. Now, whether we get it, I don't know. Justice Roberts probably is not thrilled to be hauled in on this issue. But the only way we're going to get any relief for the service members who were court-martialed and thrown in jail, thrown out of the service, fined, and basically had their careers ruined, is if we can get up in front of the Supreme Court and say, look, it's a defense to a lawful order, that a charge of a failure to obey a lawful order. It's a defense to show that the order impinges or affects, reduces a federally guaranteed right, a statutory right. The right that's been guaranteed these service members is not to be injected with experimental medications. We have a federal court decision saying they were being injected with experimental medications. The CAF has no expertise in this area. They admit that in their opinion, and yet they ignore that. So the only way these kids can get any relief, these service members can get any relief, is if we can get to the Supreme Court for a review. And so we're pushing that, and we're going to try to get it there. I put some suggested reading in place for you. The Doe versus Rumsfeld cases. The 2003 case is the preliminary injunction. The 2004 case is the permanent injunction. You need to read them together because they build on each other, but they discuss the issues that were litigated on this. Interestingly enough, back in 2001, the Duke Law Journal published a note for which I was a source. Fortunately, they didn't listen to me too much, called Friendly Fire, which talks about this program and pretty much lists the factors that were involved in this litigation down the road. I talked to there was a Duke student here named Randy Katz, and I talked to him about this as he was pulling the note together. So that's an interesting overview of the kind of factual issues that you see in the litigation. The Project BioShield Act of 2004, read that and you can figure out what's going to happen if we have a bird flu or a smallpox outbreak in the United States. The fact that, for example, the Secretary of Health and Human Services can declare an emergency, and once he or she declares an emergency, then all kinds of interesting things start happening. Isolation of affected people, mandatory inoculations of populations, the kinds of things you would expect to see in the event of a true national emergency. Casala versus the United States is that Court of Appeals for the Armed Forces opinion that I mentioned earlier. That's the opinion that says, oh, by the way, we're not paying attention to what the federal judge says in the other case. What I want you to do is read these two Doe cases and then come back and see if you can, if anybody can do this, I want to know about it. Read the two Doe cases and then come back and see if you can reconcile the Casala case's decision with what the facts that are found in the two Doe cases. I'd love to see it. I don't get it, and I freely admit that I'm an idiot. So you know, I'll turn it over to brighter minds than mine to sort this out.
While you're talking about that, you might want to tell the students about the presumption of legality issue in the military, because that, I'm not defending the decision, but that's a little wrinkle that they may not be used to, the presumption that an order is legal.
The rule in military justice cases is that all orders are legal unless they're not. Okay? And that's the best way I can put it to you. There is a presumption of legality for any order that is given to you by a commander. It has to be that way. You can't run a military without that. You can't allow those kinds of challenges or challenges to orders without that. So the short answer to that is, and every soldier is instructed in this, if you're going to challenge the lawful orders or what appear to be the lawful orders of your superior commander, you better be right. Because if you're wrong, you're going to jail or worse. Okay? So there's a presumption that orders given to you are legal. And the court in Casala focused on that and said, we presume these orders are legal because we have to. Okay, fine. And then they said, now the district court didn't address this presumption of legality. That is incorrect. In fact, the district court did address the presumption of legality, and they said, look, if you want to challenge an order, you can challenge a lawful order in one of two ways. You can either refuse to obey it, in which case you're under the military justice system through the military courts, or you can obey the order and then challenge it in civilian court. And as long as it's an order that we can address with our that it's justiciable with our justiciability requirements, then we can handle it that way. So that's a great, thank you, that's a good point. That's sort of the backdrop in the difference between the way these cases were handled. But this is what drove me crazy about this case, which is why, again, I want smarter people than me to look at this. That court said the district court didn't address the legality issue, the legality of the order issue. Semantically, that's probably correct. You will not find, in the district court's opinion, all orders are presumed to be legal. What the district court did was something a little more subtle. They said, look, here's how you challenge orders. If you're going to challenge them, you go through the military justice system or you go through the civilian court system after you've obeyed them. But you don't get to play both sides against the middle. You don't get to say, I refuse to obey the order, and then I'm going to sue in civilian court. Can't do that. Once you say, I refuse to obey the order, you put yourself under that military justice system. And the district court was quite clear on that. I left a little bit of time for questions, although since you all look really well fed, I'm not sure I'm going to get a lot, but I'll be happy to handle any questions right now. Again, just so you know, this case was taken on. It's a pro bono case through McGuireWoods. I think we're up to about my partners won't be thrilled at this, up to about $500,000 in attorney time and costs on it. We have in my e-room repository on the web, we have probably more information on the anthrax vaccine than even the FDA has. In fact, I know we have more than the FDA has, and how this program has been run and the sidelines of it. One of the interesting aspects of this case is that this, for all the knocks on large law firms, and I understand all of them, this was a case that had to be handled by a firm with substantial assets because of the time that it took to get up to speed on it, the cost that it took to establish the electronic room and repository for all the documents, put all that stuff in there, and the fact that the firm can afford to throw 6 associates and 2 partners at the case over the course of about 5 years, which is what it's been. So just to give you an idea of the scope of the work on it. But it's been extremely rewarding because, as I said, we shut the program down for 2 years. We forced the government into understanding that they can pass these laws and there are going to be people who are going to stand up to try to enforce them when the government blows them off. And that is sort of what's happened here. So I will be happy to take questions either in the group or I'll take them individually. Go ahead.
Yeah, I was just curious. Obviously, what you're largely challenging is process.
Yes.
And whenever you challenge process, there's got to be some sort of feeling of, well, inevitably, even if we win in this round, they'll just come back and fix the process and then we'll lose. Do you have sort of that, or how do you sort of overcome that?
Oh, sure. I always consider it a win when I get the government to follow the law. So that's my first, that's my first move. The win that we had in this case was to force the government to acknowledge that statute up there had some teeth to it and had some effect. So that was the first thing. The government then, has sort of fallen into our laps with regard to the way that they processed the application for the vaccine after we got the injunction. So they didn't correct anything. They simply the FDA waved its magic wand and said, oh yeah, we looked at all this paper, blah, blah, blah. We think the vaccine's fine. They didn't correct any of these other issues, and DOD didn't bother to correct any of its problems either, which is why we're going to go back in and try to hammer them over the head. I am not an anti-vaccination person. I mean, there are sound, legitimate reasons to have these troops vaccinated. What I want is them vaccinated with something that's not going to do more harm than the vaccine or than the threat that they're exposed to, and that really is the issue. I mean, we have roughly 1 million people right now who have been injected with this stuff to varying degrees in varying levels. All right, we have no clue what the long-term effects of this stuff are. We don't know, for example, when these people turn 50 or 55, whether they're going to start, a larger number than we're going to start developing these problems. We have no idea about the long-term effects on women. It also seems to have a disproportionately large effect on African Americans. None of this was tested. And, I have a certain affinity for people in uniform, and I think this is outrageous that they're having to fight this. I mean, it's bad enough given the circumstances that they operate in under on a normal day-to-day basis without our own people, exacerbating the threats that they're looking at. And the other aspect of this program, and this is just again an aside, this program is no longer threat-based. The government started out by justifying it, saying, look, we've got a lot of people, a lot of countries out there that have anthrax, and we expect them to use it as a weapon. That's no longer the basis for the program. The basis for the program is we've got all this vaccine sitting out here that we've just paid $10 million for. We want to use it because we have it. And yes, ma'am.
Yeah, I have two questions. Talking of the litigation, I would like to know who is the defendant. Because I'm assuming maybe it's different from my country, the country I come from. The defendant is the military or the FDA or any government agencies or the company produce this vaccine is the first question. And the second question, can you talk more about the burden of proof during the litigation?
Okay. The first question was, who are the defendants? Under federal law, I have to sue the secretaries of the cabinet levels that are running these programs. So I sued Donald Rumsfeld. This may be very popular, by the way, when I was a reserve officer, that I had a lawsuit against the Secretary of Defense. I sued Donald Rumsfeld, and I sued Tommy Thompson, who was the head of the Food and Drug, or head of Health and Human Services. And then I also sued, I've dumped his name now, he was the acting head of the Food and Drug Administration. So those were my three defendants. I did not sue the manufacturer because the manufacturer is removed from this process in terms of certifying it. Now, the manufacturer cannot be sued by the service members who got sick because of something called the government contractor defense and the Ferries Doctrine, which precludes active duty service members from suing the government or its agents for acts of negligence. And then the other question was the standard of proof?
Burden of proof.
Burden of proof. Oh, I had the burden of proof the whole way. We had the burden of proof. We came in, we demonstrated, had to demonstrate to the court for the injunction that the government had violated its own statute, its own procedures, had violated its own procedures, was continuing to violate its own procedures, and the only remedy was to shut the government down and stop them.
Should you prove the injury to the personal injury? Because you mentioned some injury maybe to long term is very difficult to prove. So I'm just wondering.
My personal opinion is that people will find it, much like the Agent Orange cases, they will find it very, very difficult to establish long-term health effects as a result of exposure to the vaccine. And in fact, for many of these people, it may be a combination of things involving the vaccine and other environmental factors. Smoking, job choice, genetic predisposition. There are a whole bunch of things that factor into this. What I can tell you is that the people who are getting sick now have a straight, clear link that's already been validated by the Veterans Administration. They have a straight, clear link to the vaccine as the source of the injury. And we can point to those directly. What all of us are afraid of in this business is some kind of horrible long-term health effect that develops when people are 40, 50, 60. And that's going to be a large cohort. It's going to be about 1 million people. And we'll start seeing how that plays out. Sir.
A couple of questions. One, was the Kusawa opinion a unanimous opinion?
It was.
And secondly, how did you get your experts? That must have been quite a test.
We've only got one expert, and there's been no expert testimony in the two cases we had. The way we got expert testimony on this was we used the government's own documents. We were able to get in to find the government's own documents saying, here's the investigational new drug application, here's the failure to take in comments, and we simply put those in front of the court and said, you don't have to take our word for it, here's the government saying this themselves. And in fact, one of the funny things, the oral argument on summary judgment for this case was 2 hours. I was on my feet for 2 hours in front of this judge. Standing next to me was another reserve officer from the Department of Justice. And we stood up there for 2 hours and went back and forth and back and forth. And one of the great things about it was, you know, DOJ has a lot of cases on their plate, so do I. But because of my database, I had a lot better information than he did. So when he said, you know, that IND application, investigational new drug application, is no longer valid, I turned, walked over to my table, pulled up the folder that had the updates to the IND application that had occurred within the last, some of it had occurred within the last 6 months. I put that in front of the judge. You only have to do that 3 or 4 times, and the judge starts to get the impression that you know what you're talking about, and the government doesn't.
Lou, on behalf of all of us at Duke Law School, I'd like to thank you very much.
My pleasure. Anytime. Thank you. My pleasure.